Good day, ladies and gentlemen, gentlemen and ladies, ladies and gents. If I may have your attention for just but a moment, the Sitcom Arbitration Association, otherwise known as SAA Limited, is asking for individuals who are interested to apply for the position of arbitrator. The individuals who apply for the position of arbitrator will receive $200 for each arbitration they review and oversee. They are required to spend at least 1 hour in such review and to record such review. It is, and I said $200 an hour, I must apologize. It is a guarantee that they will receive at least $200 for the first hour, but it is $100 per hour per review of arbitration, not $100 per hour per day for effort, but for review of the arbitration and for issuing the award. It is $100 per hour with a minimum requirement of 2 hours. So if it takes an individual, if the contract is, for instance, 9 pages and the complaint is another 2 pages, and it only takes them roughly 30 minutes to go over, it is still $200. However, they must record the entire proceeding on video to document that they did in fact go over it. The individual will be required to have at least a high school diploma and or a bachelor's degree and or a master's degree and or equivalent of college education. There will be a need for some sort of administrative history, such as supervising and or working in an office and or handling paperwork in an office setting. There will also be the need for an individual to provide a resume along with an application. SAA will furnish a copy of their application for you to fill out in order to apply. You do not, repeating this, you do not have to fill out the application on the site. That is for a different purpose. They will provide the application when you send your communication to application@saalimited.com. You will be required to go back over this video to find the instructions and the information as to what is required. Please do not bombard the email system by asking questions that are already covered in this tutorial, or you will simply not be considered. This tutorial will cover all of the necessary information required in making an application. Please allow up to 2 weeks to receive a response. Sorry, we are having, as a result of someone doing videos regarding arbitration and Supreme Court decisions, an overwhelming influx of emails. We also need to let you know that there are, within the system, over 36 gigabytes worth of email communications that we have backed up and are transferring to our new hosting location. That will be completed within the next hour. So there has been a backlog that SAA is having to attend to. So please be patient. The individual applying will have to go over the articles in the link below. They will have to have a crucial or cursory or general knowledge of the information in each one of the links below the video. The first one is the case of Mr. Chess versus Mr. Burt. In this case, it involves an individual doing what's known as an assignment for redemption rights on a property. There has been a contract generated out there in society that the assignment includes an arbitration clause agreed upon by the parties. It also suggests that SAA be the arbitration association to oversee any conflicts involved in that particular contract or transaction at Commerce. You'll be required to understand the basics of chess versus Burt. The link will be below. Second, you'll be required to go over the article. Now, this is a rundown of what the Supreme Court decision was in the case of Sheen Inc. versus Archer and White, where the Supreme Court has determined that if the contract, as is the case of the one we just mentioned, and several others, mentions that the parties have elected to have any and all matters associated with the contract, whether directly or indirectly associated, addressed by an arbitrator, that the courts have no jurisdiction, they must yield to the wishes of the parties. You will have to go over this and understand exactly what is being said, which is why you're given 2 weeks to have this information understood. The ones who fail to answer the questions when asked regarding this information will not be considered, because it will mean that you didn't take this information seriously. This is not a game. This is not something to be taken lightly. This is not employment with McDonald's. Sorry, disclaimer. McDonald's is a very professional environment to work in, and their employees are required to do their jobs to a professional degree so as to provide proper customer service. Sorry. Now, let's continue to the next article that you'll have to be familiar with. Again, each link will be in the description below. This is the actual Supreme Court case. You will have to know what a syllabus is. That's the first thing you'll have to know. And this is a syllabus, but you'll have to understand what it is, so it is suggested that you look up the legal definition of the word syllabus. Second, you don't have to know what a certiorari is. Certiorari. Do you understand certiorari? Do you understand the term? There are many of you out there who have some legal background. Legal history, legal background is not required in this position. However, you will need to at least have a familiarization with the process of certiorari. So do the legal definition of the word certiorari so that you understand why and what is going on in this case. You must go through this because it involves directly arbitration. This is a precedent-setting case that will govern how arbitrations are done from this point forward. It applies to every court, every state, every jurisdiction. Now, again, the Federal Arbitration Act. The Federal Arbitration Act will cover 2 links from now. Well, actually, I apologize. This is the Federal Arbitration Act here. It's Title IX of U.S. Code. Now, you saw the Cornell Law version. You'll receive this version because this version is a little bit more detailed. As a matter of fact, you'll be able to follow the outline better. There are certain provisions which each arbitrator must know. You must know under what you have authority. Arbitration is a private process, but the arbitrators are to follow certain guidelines. This act has been in place since the 1920s. Get to understand its history, get to understand its provisions. If there is a word or a phrase you don't understand, literally take that phrase and paste that phrase into Google or any other search engine, and you will get an explanation of what the phrase means. There are a lot of phrases that are legal terminology that most people won't understand. There are some things in this particular act that won't apply. The individual who understands the most about this information will be the one who will receive the more accounts assigned to them. So your knowledge of the basics of arbitration will depend on how many cases are assigned to you while at that organization. Please understand that the EEON channel and SAA have no affiliation. The only thing we provide is logistical services. Since I am the one who did the first advertisement of the organization, asked that I let you know of the opportunity. And I agreed that I would do so. Finally, the last article you will need to know is these are the arbitration rules and mediation procedures for an organization known as the American Arbitration Association. The American Arbitration Association was created by the American Bar Association. Thus, you see the scales. Now, this is nothing against or for the American Bar Association or not the American Bar Association. What you need to know is most of their arbitrators are all attorneys, which means most of their arbitrators are a part of the American Bar Association, which means that any case that deals with the court, that deals with attorneys, that deals with any legal organization, especially a law firm, presents a conflict of interest whereby the parties agree to ignore that conflict of interest. SAA is not associated with any organization, especially any company and or organization that would be in conflict with any of the applications they receive. If there is a conflict, they immediately let the parties know of this conflict. SAA, even if the parties agree that SAA can hear their matter, SAA will make a determination via their board to determine whether or not they will accept the conflict of interest. SAA will try to always do things according to law, according to reason, according to what's right. SAA will not take sides. They will not side with you. It's not you against the system. It is what the contract says and whether or not the contract itself is reasonable and whether or not the things being asked of each party is reasonable and that the parties are capable of carrying out. That the contract must comply with the rules of a contract. What are those rules? That there must be two parties who have agreed, at least two parties. That there must be value in the contract, whether commercial, property, or otherwise. That there must be some sort of consideration where somebody has made some sort of a payment or exchanged something for something else. There has to be an exchange, consideration. There must be an assignment of duties where one party has agreed to do something and another party has agreed to do something, and then there has to be a listing of what the consequences are if the party failed to do it. Each contract must contain an arbitration agreement. Because the contract needs to contain an arbitration agreement, if the contract does not contain an arbitration agreement, SAA will not hear the matter. Yes, other organizations will hear a matter if the parties agree to arbitrate, even though their contract did not contain an arbitration agreement. SAA does not wish to be placed in such a position, so they are only handling matters that deal with arbitration. Finally, the arbitration process requires that SAA issue an award. The person applying or requesting arbitration must follow the instructions on the website. They are clear, they are crisp, they are simple. SAA cannot tell you how you can arbitrate a matter. They cannot tell you or give you advice on how you should create a contract or what you should put in your contract. They cannot offer you any advice because this is a quasi-legal matter. They are prohibited by law from giving you such advice. But what you can do to get a better understanding of arbitration is you can go over this document here with the AAA. Now, please understand, SAA's rules and procedures for arbitration are on their website, but we want you to understand as arbitrators what the other organizations are doing and have done. Okay? Now, AAA has been around for quite some time, and so that's why we use them as an example. They are not our rivals at SAA. They are not competition. SAA is in a league of its own because SAA is here for the small people. SAA is working out a plan where they will handle a certain amount of arbitrations pro bono. The law requires that arbitration organization provide arbitrations for low-income recipients, which is why we have reduced every arbitration to $500 is the base application standard price, $500. Why? Because the actual price is $2,000. So we automatically defer the cost of each arbitration, with the exception of those who are asking for extra services as documented on the site. So when the organization was set up, it was set up because of the low-income individuals. No other organization had done anything like this, so that's why their base price was $500. We have already deferred the cost. So please understand, we've already taken into consideration low-income individuals. There is no payment plan. The law does not require an arbitration association have a payment plan. There is nothing scheduled in the future for creating a payment plan at SAA. We will do several cases per year pro bono, where the individual coming to SAA who is incapable of paying will be put before the panel, and the panel will make a determination whether or not to accept that individual's arbitration. However, there will need to be proof provided, and SAA will determine what proof will be necessary to prove that the individual is unable to pay. The arbitration award that is issued by SAA, the original will be issued to the individual making the application. That original will come with a certified copy with a stamp and a seal and 2 signatures. If the individual would like to have that stamp seal notarized and then certified, that will be an additional cost of $65. However, there is a provision for having such done. You can communicate with SAA for the details on that. Please, the details aside from what's given here will be given. Any information that is covered in this video will not be redistributed to individuals based upon any other information, email, telephone, or other communication. Arbitrators will also act as customer service representatives. It is a 2-pronged position. Each position comes with a subcontracting classification. What is a subcontractor? Well, it's someone who literally provides services independent and receives some sort of payment for those. I apologize for that, ladies and gentlemen. Some sort of a payment or contribution or grant of monies and or fees for such service. But they are not a direct employee, such as an individual hiring an attorney. He is a subcontractor. He receives fees. There are administrative fees associated, and that's explained on the site. We are hoping that this explains what's being offered at SAA And let's take you to that site again, which is located at SAAlimited.com. Again, SAA is looking for arbitrators who will work on a subcontracting basis, receiving per arbitration $100 per each hour, and there is a $200 minimum payment for the first hour. So even if they only contributed an hour and 15 minutes, the $200 is guaranteed. There is a board. There are a total of 6 members on that board. They need 3 more board members. So depending on the qualifications and the effort and the professionalism brought in by the individuals who are applying, they will be considered for the alternate board member positions that are remaining available. Thank you for taking the time to watch this. This will be up on the SAA's site for your information, and it will remain up on this site for the foreseeable future. Have a good day, everyone.